I'm James Klobucar. I'm a partner here at Gearhart Law. And one of the top questions I get from potential clients as well as existing clients is, what happens when either I or someone else needs to assert my patent rights against someone? What does that look like and what does it mean? And many a times this comes up when a client of ours receives a cease and desist letter from a third party. And the cease and desist letter is really kind of the jumping off point for any potential litigation. It would be quite rare that a party just files a lawsuit against someone. Typically, there's going to be the sending a cease and desist letter, likely a little bit of back and forth between representatives for the parties, and hopefully the issues can be settled long before litigation hits. Because the short answer is you don't want to be involved with patent litigation. It's time-consuming, it's expensive, and at the end of the day, it's in nobody's best interest. But sometimes you have to enforce the rights that you spent so much time and money looking to obtain. Assuming that the matter can't be resolved in that early cease and desist letter, settlement, discussion, negotiation phase, typically what happens is you would draft a complaint and file the complaint with the appropriate court having jurisdiction over the matter, after which there's going to be a length of time by which the party who you filed the complaint against to file their answer. Once the answer's been received, you move into the next phase of the litigation process, which is the discovery process. During discovery, each party can make requests of the other party to share information, and the exchange of information may be in the form of written questions, it may be in the form of documents, and it allows each party to find the relevant discoverable information that can support or deny, their potential claims in the complaint or any sort of counterclaim that's been filed. So after you've gone through the discovery phase, and specifically fact discovery, there may be the need for expert discovery. Now, whether experts are going to be required for your particular case, that's going to come on a case-by-case basis, and there's going to be strategic decisions as to why you would or would not retain an expert. After your fact discovery, typically you do any dispositive motions, such as summary judgment, before moving into expert discovery. And after the whole discovery is complete, the court will typically schedule your trial periods, motions, any other pre-trial motions that you may have. But it's important to know that at the end of the day, it's quite rare for a case to see the inside of a courtroom and to see a jury. Probably 99% or better of cases do get settled sometime during the discovery process. And it's just a matter of how best can we find a way to settle for the parties that is going to be something that everyone can live with, rather than leaving it up to the mercy of a jury, or if there is no jury, the court to make a decision, in which case, one party could lose substantially. In patent litigation, the best strategy is typically to settle. However, that's not always practical, and it does take two parties to reach a settlement. So in the event that you find yourself in settlement negotiations that aren't panning out, or you find that you need to file a complaint against a third party, or a complaint's been filed against you, please feel free to reach out to us, and we'll be happy to prepare a frank assessment of the matter at hand and represent you in any way we can.